was in the womb. So the legislature could have made that clear. It did not carry forward that part of Byerly. I think it did make the rights more expansive because it made it clear that the 10-month period is a presumption, essentially, and as Byerly instructs on a former statute, it's a fact question before the court. And that fact evidence should have been developed before the case was dismissed. And so, for example, the appellee has argued both at the trial court level in the arguments before the court and also in its appellate briefing that, you know, a child born, you know, this could open the floodgates to a child born 30 or 40 or 50 years later. And for example, there's no evidence in the record. Is that even possible scientifically? What are the outer limits of a viable egg? That evidence has not been developed, and yet it's an argument the appellee makes. Similarly, the appellee has argued both below and to this court about this specter of the other fertilized eggs. You know, the specter of eggs being implanted, and maybe there'll be multiple more heirs. There's been no evidence developed as to whether Hosna Avital has any intention whatsoever of implanting more eggs. That evidence could have been developed. There's no evidence, for example, showing what Daniel's intentions were concerning posthumous implantation. I think evidence would be adduced from both witnesses and the clinical record about what his intentions were, about whether those eggs could be used after his death. So I think there were multiple factual questions that could have been addressed at the trial court level, but the case, I think, was prematurely terminated by the trial court. And again, one way for this court to address that is to reverse and send it back to the trial court for development of a full record. The court could also reach the ultimate question of what the statute requires. Again, it's silent as to the rights of a child after that 10-month lunar period. The only case that remotely addresses this addressed a prior statute, so I think it's instructive law but not binding on this court. And even under the more restrictive statute, which said no child shall inherit 10 months after, even under that more restrictive statute, the Byerly Court, the Supreme Court in that case, in 1959, created a rebuttable presumption that a child born more than 10 months could inherit. There, the court tied it to the question of whether the medical evidence, whether the factual evidence showed that the child was in utero at the time of death. And I think that timing and the state of science at the time is important to that question, because if the touchstone is the court was concerned about ensuring whether there was actual paternity, is this the biological child? Well, there was really only one way to have a child at that time. So tying it to the question of whether or not the child was in utero was a way for the court to ensure that there was paternity, that there was a biological connection. Now, we have a variety of other ways to address that. And
well, but Byerly also, and I'm looking at the toward the end of the court's opinion, and the folks on the other side of the aisle will probably know that I'm going to ask them that question again, because what the court in Byerly said was, thus, when the issue is raised, the burden of proof rests upon the child to establish by the greater weight of the evidence that the intestate was the father.
yes. Yes. And
I mean, they've talked about being in utero, they've talked about the 10 months, but the holding is that, and it got sent back, as I recall.
Exactly, Your Honor. And so again, in 1959, the way to ensure, the way to ascertain, to determine the factual question of whether that was the child's father was making sure that the period of time was not so extenuated and extended that the evidence would support that it was the child. that is no longer an issue here. Again, our complaint expressly pleads DNA establishes that Noah is the actual child of the decedent. That fact has to be taken as true on a 12b6.
So how do we address the fact that while our General Assembly has taken steps in other statutory areas to sort of acknowledge and incorporate IVF, that in this statutory regime and under the statutes we're dealing with, the General Assembly has effectively taken no action that would sort of incorporate the use of IVF in recent years?
Well, I think that goes both ways. In 2012, there was a fairly extensive rewriting of both Chapter 28A and Chapter 29. This statute remained untouched. And I think had the court intended to ensure that IVF could not be used to extend or used to extend past the 10-month lunar period, they could have addressed that at that time, and they chose not to. So I think leaving it open as a factual question, which I think was the legislature's intent when it adopted the statute in 1959, and then the court could have tightened that, the legislature could have tightened that up in 2012 and didn't, still leaves it as an open factual question going back to Bost, is this the father? And so,
but in those circumstances, I mean, you make a good point. IVF is here. It's not going anywhere. We want to, of course, encourage people who cannot otherwise have children to engage in IVF, but the embryos are there for an extended period of time. You know, other states have statutes that give a certain time period in which the embryo must be implanted in order for the child to inherit under the will, and that doesn't exist here in North Carolina. And it seems as though if we were to take your approach, we're kind of opening maybe Pandora's box, and children who are implanted 6 or 7 years later could claim inheritance.
well, I think it's not unusual for the court to look at what is a reasonable time period for bringing this, and it could be that one time, in one day, the court will be faced with a question of a child trying to bring a claim too many years out and determining what is the time limit here. I'll note that in this particular case, this action was brought by Michael during the administration of the estate, not terribly long after his brother Daniel died. I think a timeliness question as to this existing child doesn't present to the court here. However, I think that the courts often establish reasonable time limits, and this is a little bit of a different circumstance because obviously it didn't address an IVF baby, but for example, in the Bost case cited in our reply brief, that dealt with an adult child bringing a claim, I don't know, some 30 years later, making a claim that he's an afterborn child under 30-5.5. And the court there rejected his claim as being brought too long after because he can't, he can't wait that long to establish it. And the court there looked at it and said, there's a 3-year statute of limitations for bringing this kind of claim. So I think that the court can certainly address issues of timeliness. The courts do that all the time. I think, a 3-year statute of limitations under Bost makes sense. But at any rate, I don't think the question of, is this claim timely? Is this claim in particular that's before the court going to hold up administration of an estate? I think that's not presented here because it was presented, again, not long after Daniel's death and during the active administration of the estate. That answers your Honor question.
Thank you.
At any rate, the question here is whether the judicial rule established interpreting the prior statute of a requirement that the child be in the womb, should that stand? Again, statute didn't include that requirement. The legislature could have included it had it wanted to, could have said the child had to be in being, the child must be in the womb, some language to that effect. It chose not to do that. I think the court here must evaluate whether or not these facts should have been more fully developed at the trial court level, and again can reverse to send it back for that factual development, or the court could reach the construct in light of the statute as it exists and give some guidance to the parties. So, thank you.
Thank you.
Good afternoon. May it please support, my name is Abby Bechtel. I'm here from the law firm of Shoemaker, Luke, and Kendrick. And I have the privilege this afternoon of speaking on behalf of Hasna Avital, both individually and in her capacity as guardian for the minor child, Noah, whose existence is why we're here today. Hasna and Noah are both in the courtroom with us today with Michael, here to devote attention to this issue and to show their support for Michael's request that this court reverse the ruling of the lower court to hold that motion to dismiss was entered erroneously. I'm here to advocate for Noah today. I share in the position of appellant and appellant's counsel. To that end, I don't intend to necessarily rehash anything that's already been covered today. The court, obviously, by its questions, is very aware of the issues. They're very tuned into the specific portions, especially of the Byerly case, that are relevant to this issue. So I do expect that my argument may be a little short, and I may allow appellant's counsel to reserve a bit more time in reply than I intended, because again, the court's very tuned into the specific issues. I do think that, to echo appellant's counsel's position in response to the court's question about whether or not we have to even reach the substance today, I think we certainly can rule on this appeal, on the issue on appeal, without reaching the substance. But I think a discussion of the substance, especially contrasting my position and appellant's position on the substance, when contrasted with the position of Deborah Clark's position on the substance, that just goes to show, even if the court doesn't rule on the underlying issue of Noah's inheritance, it does show that it does support the position that there is a genuine existing controversy, such that the motion to dismiss the request for a declaratory judgment should not be granted.
So getting back procedurally, how does this claim arise? Was this a claim filed with the estate initially seeking this inheritance by, on behalf of the minor child?
So it's my understanding it was filed by Michael Avital in his capacity as executor of the estate, as well as in his capacity as trustee of the general trust that the estate establishes, that Daniel's will establish.
Because there are multiple claims
There are.
in this case.
There are several claims. I think at one point, I know one of them's been dismissed. There are several. We're dealing with the first, which was essentially a claim from Michael saying, here's our position. We have this statute. Obviously, the trustee for the special needs trust disagrees with our interpretation. We need some guidance from the court in the form of a declaratory judgment to say which way we need to go. We need assistance on this question, and that's the issue that's before the court. Ms. Clark moved to dismiss that particular cause of action, and that's before the court.
Then did a Rule 54 certification to certify it up to us on that particular, the dismissal of that particular claim.
That's correct. That is how we are here today, because I think the ruling on the 12B6 motion doesn't really help Michael in his decision. If we were to uphold that ruling, Michael still has no guidance as to which way he may be required to distribute the assets of this estate. The 12B6 order is very short. It's, of course, it's very general. It says, based on the pleadings and arguments of counsel, I find there's no cause of action. The cause of action being a controversy such that a declaratory judgment is warranted.
And the possibility of a direct claim against the estate by your clients?
I think it does. I suspect, without assuming, that that's part of why Michael, in trying to acknowledge and meet his responsibilities, why he had to request this input from the court, because he doesn't want to do something like administer all the estate assets a certain way and then open the estate or himself personally up to any liability as far as whether or not he failed to meet an obligation to Noah, to Ava, or to Daniel himself. So I want to talk about one issue. In addition to having to address the application of the Byerly case and whether or not the relevant statutes support Noah's right to inherit, one thing that Michael also has to grapple with is the idea of whether or not there's some other principle that course, Noah's rights to inherit that he may need to use as basis to distribute the estate assets a certain way. And one of those possibilities is the principle of equity that may, based on what we know of Daniel's intent with regard to Noah, based on what we know, Michael may have an equitable responsibility to distribute the assets a certain way in order to include Noah. Appellant's brief gives a very general, very basic description of the IVF process. Even at that very high level, I think the court can understand that it's not a quick process. It's not something that either party can participate in passively. Both parties have to take affirmative steps in their effort to create this child. I say that not only to bring the court's attention back to the significance of what we're talking about today, but also to point to the fact that the pleadings establish, of course, that Daniel and Hosna both participated in to create Noah. That fact, and especially the fact that Daniel and Hosna went so far as to select the precise embryo they wanted to become their child. And I think that clearly shows Daniel's intent to have Noah specifically as his child.
To actually include children or any children in his will. I mean, he did revise his will after he and his wife got married, but it doesn't appear that there's mention of children.
I think that this is not the first instance where we've seen a situation where someone just makes efforts to have a child after a will is executed, even has a child after a will is executed, and they just for whatever reason do not take efforts to amend that will. Of course, that would make our job here a lot easier, but I think that that would be an excellent indication of Daniel's intentions, but I don't think it's the only thing we can use to figure out what Daniel's intentions were. So in our brief, we have analogized the circumstances of this case to one in which the Supreme Court held that principles of equity would support inheritance where technicalities and failures of the law may otherwise not support inheritance. There's a Langford versus Wright case that says a situation where there are two parents who intend to adopt a child and they take a lot of efforts, they start the paperwork, the child's using their last name, she's known around town as their child, but for whatever reason, they can't formalize the adoption process before they both die. And when that child came to court trying to claim a right to inherit from those parents, the court for the first time in North Carolina recognized this concept of equitable adoption. And they reasoned that based on what they could see of what the parents' intentions were before their death, equity required the child to be given a share of the estate. They looked at 6 or so factors, some of which apply here, some of which admittedly do not. They're specific to the situation of adoption, but they looked at things like whether there was an agreement to undertake these acts to make this their child. They looked at specifically what affirmative steps they took to complete this process, and the Langford court eventually held that equity required them to essentially put that child in the same position in which she would have been. And I think we can use the general principles behind that concept to apply here. The court and Langford said we can use equitable principles to fashion a remedy where mere technicality is going to yield to an injustice. And here, if we take, even considering the Byerly case, if we take the fact that the date of Noah's birth for some reason precludes his inheritance, the court could still use equitable principles to fashion a remedy for him, essentially treat him.
The question, again, putting it back in the declaratory judgment setting, is declaratory judgment really the setting where we're trying to determine rights under particular statutes, the place to fashion equitable remedies?
I don't necessarily think that that is the vehicle to how we get to using an equitable remedy, but my point about the potential equitable considerations goes to simply the fact that Michael has to contend with a lot of things in making this decision. Again, to the earlier discussion of whether he's going to open up himself or the estate up to a potential claim in the future if he does things incorrectly. These equitable considerations, in addition to interpreting the statutes issue, they're things that he's going to have to contend with in order to make this decision about how to distribute these assets, which goes to why there's an existing controversy, why we need this input from the court to make this decision. So Unless there are any further questions, my understanding of appellate would like to reserve about 5 minutes in rebuttal, so I will conclude with that.
Thank you.
Good afternoon, and may it please the court. My name is Kim Kirk, and I'm an attorney at Johnston, Allison, and Horde in Charlotte. I'm accompanied today by my colleague, William McClelland, and we represent Deborah Clark in her capacity as trustee of the Special Needs Trust for Ava Avital, as well as in her capacity as guardian of the estate of Ava, who is, as you've heard, a minor. Your Honor, appellant's position requires the court to adopt a new standard for determining who constitutes an intestate heir in North Carolina. And that's because it reduces the inquiry to one of genetics only. And the court alluded to this earlier with the question about the Pandora's box. If we adopt appellant's position, the question just becomes, is the afterborn child the biological child or not? And that is not the law in North Carolina.
Well, you say in your brief that the statute says that 10 months is it. I don't read the statute to say that. I read the statute to say that if it's within 10 months, then you've got to recognize it. It doesn't say that if it's outside, you can't. And in fact, this statute is broader than the statute they were considering in Brierley, is it not?
And so I think the statute needs to be considered in the context of Chapter 29.
Well, what about in the context of the, if you're born out of wedlock, you get 12 months as opposed to 10? Isn't that also a part of the statute?
Yes. And Your Honor, both of those statutes need to be read in tandem. So I'll back up a moment. Chapter 29 establishes a statutory right of inheritance under the intestacy laws. Intestacy, the right to inherit by intestacy is a statutory right. And if you don't fall within one of those classes identified in Chapter 29, you do not have a right to inherit by intestacy. And if you look at the definitions under Chapter 29, in 29-2, the definition of heir is a person entitled to take under the provisions of this chapter. And so in order to even become an intestate heir, you have got to fall into one of those categories. And so in this case, for an unborn infant to fall into one of those categories, we're looking at 29-9. And the only right of inheritance that is extended to an unborn infant under North Carolina's existing intestacy laws is to those unborn infants who are born within 10 lunar months of the death of the intestate. Now, Your Honor also asked, well, how does that mesh with what we see for children born out of wedlock? Because there is another statute in Chapter 29 for children born out of wedlock. And those two statutes need to be read in tandem. Because if we just pick the statute for the child born out of wedlock, or if we just pick the statute for unborn infants, we are just picking and choosing statutes.
Well, how's it more equitable for a child born out of wedlock to have 12 months than a child born to someone who was married and died? How is it equitable for there to be two separate things? And how can you read the legislature as saying 10 months is it?
You're right, Your Honor, that it would not necessarily be equitable to have a longer period of time for children out of wedlock. And I understand that's what the appellant has argued in their brief. That is not respectfully how I believe the statute reads. What that subpart B3 reads is that a person, we're talking about a person who died prior to or within 1 year after the birth of the child. And so that 1 year provision applies to the after the birth of the child. Otherwise, if you break the sentence apart, I mean, the only way you can read it is a person who died prior to the birth of the child or within 1 year after the birth of the child. And so if we're looking at,
Is that how the statute's been interpreted?
I believe that's the only proper interpretation of the statute, and I'm not aware of it being interpreted otherwise. And what I would say is that we can give meaning to both of these statutes. It just means that there are two hurdles for our unborn child, or our unborn infant, who is also a child out of wedlock. First, they have the hurdle, they have to be born within 10 lunar months of the death of the intestate. And second, under 29-19, they also have to ensure that notice is given to the PR of the estate within 6 months of the time the notice to creditor runs. So there are additional hurdles, but those two statutes can and should be read in tandem together. And so, Your Honor, and the court, what I would like to do today is I had planned to kind of walk the court through these pertinent statutes, show how they interplay together.
I'd like you to also talk about how this is a 12B6.
Yes, and I'll start with addressing the court's procedural question. So a declaratory judgment action is properly dismissed where there is no basis for the declaratory relief sought. In this complaint, in paragraph 55, the plaintiff asked for and this is a quote, a declaration that Noah is an afterborn child of the decedent entitled to share in the estate under 31-5.5. They asked for an affirmative declaration that this child will inherit.
But wouldn't it just been a whole lot easier procedurally if the court had just said, no, the child's not entitled to, rather than dismissing the action?
And I think that's what the court did say with the motion to dismiss and the order granting the motion to dismiss, because a motion to dismiss is properly granted on a declaratory judgment if there is no basis in law that supports the relief sought. Here, the relief sought is the declaration. And so by dismissing the declaratory judgment claim, the court is holding that there is no basis for this child to inherit under North Carolina's intestacy laws and in turn the pre-terminated heir statute 31-5.5.
Isn't that exactly why 12B6 is improper here? Because that sort of requires a declaration of the party's rights under the Declaratory Judgment Act.
I don't know that I necessarily agree with the court on that. I mean, there are plenty of cases in this state where motions to dismiss have been granted on declaratory action or declaratory judgment claims. And that's where there is no basis in law to support the relief sought. And here, because we have 29-9 in this bright
Well,
line.
most of those cases, though, are where they haven't where they haven't proved a controversy. Is that not correct? They haven't shown a controversy?
And respectfully, I would contend that there is no controversy here.
Well, there is a controversy here.
Oh, and I'm aware of cases that are out there that say just because the sides don't agree doesn't make it an actual and justiciable controversy. And I believe that what the trial court
Well,
held,
this is a question of first impression, so isn't that an issue of at least a controversy?
Your Honor, I would contend to the court that this is perhaps not a question of first impression, and here's why I say that. Because there has been one constant through the ages, and that has been that the average gestation period for a child is 10 lunar months. That has been a constant. And 29-9 reflects that constant. And so we're not necessarily talking about whether the law is outdated. It's just a question of whether or not the law should be changed to broaden the window of opportunity for a child born of IVF to inherit.
Well, doesn't Byerly cut against you as opposed to for you?
Well, Your Honor, I believe the second to last paragraph in Byerly starts by setting forth what it describes as the applicable rule. And I know we talked about some of the language in that earlier today, but the second to last paragraph does start, the applicable rule is this. If under such circumstances, a child is born more than 10 lunar months or 280 days after the death of the intestate, the presumption is that the child was not in ventura sed mare when the intestate died. So the presumption is that the child was not in the womb. It's not a presumption of parentage. It's the presumption of in the womb. And that goes back to the one constant that I mentioned before.
But the final sentence in that says, thus, when the issue is raised, the burden of proof rests upon the child to establish by the greater weight of the evidence that the intestate was the father. Isn't that the holding?
I don't think that is changing the nature of the presumption. I think what it is saying is that a way to rebut that presumption is to show that the child is in fact the biological child of the parent.
Well, here the child is the biological child of the parent, isn't he?
Yeah, we haven't engaged in fact discovery, but at this point, we have no reason to believe that the child is not the biological child of the parent. This statute, or this case was before 29-9, but in any event,
Or restrictive statute too, was it not?
the prior statute did include the language that Your Honor asked about before, that has been removed from 29-9, just because to have a statutory right of inheritance, it has to be somewhere in the statute. That is true. But what I would also say is we all acknowledge that this 1959 case was before IVF. And so the court was not presented necessarily with the opportunity to consider, well, is in the womb going to be different from, is it the child's father? And there are a number of very compelling reasons why it makes sense to have a finite time at which classes of heirs are determined. Now, there is a reason. There are probably many reasons, but when the legislature overhauled the statutes in 2012, as you heard today, they didn't change 29-9. 29-9 is the bright line rule of 10 lunar months. And here's the thing, if we don't have a bright line rule, we create new law in North Carolina because we have a class of beneficiaries that does not close, at least not with any definitiveness.
Well, doesn't it close when the state administration closes?
That's precisely the concern. It doesn't. And so let's use,
Not. If the estate's been closed, assets have been distributed to the heirs,
That
it's
is-
over.
that is precisely the concern. Because just because the estate administration closes doesn't mean that another embryo couldn't be implanted. So today, for example, we are here talking about Noah, today. But if there are other embryos,
The bright line when the administration of the state closes.
that's not what the law is though. And maybe
Not
that,
10 months either. I would respectfully suggest that you.
and maybe the law should say that the estate administration closes, or that the class of heirs closes at the time the administration closes. I'm not aware of a statute that says that, but I agree with the court's concern that there is a problem if an estate closes and then we continue to have heirs. Because with IVF, we could have an heir that isn't born until 10 years after the estate is closed. And I'm not aware of any statutes that would say that that heir born 10 years later can't come back and say, well, I was just born and I'm part of the class of beneficiaries and you need to recut that pie because I'm entitled to a share of it. And so let me give another example.
Isn't there some statute of limitations questions that cut against what you're saying is this Pandora's box that you say they're asking us to open?
I think that the statute of limitations is told while one is a minor. I don't know that our statute of limitations, I don't know that we have a statute of repose on that, for example, for a claim against an estate that would address that concern. And so maybe the next embryo is in a month, maybe it's next year, maybe it's 10 years from now. But unless we have a mechanism that helps us answer, how do we close estates? How do we ensure that real property is vested in the right beneficiaries? I mean, these are open issues. And I don't think that they're just unique to the IVF context. Because consider this example. If you accept appellant's argument, and you have an uncle, and he leaves his estate to his nieces, and the uncle dies, well, under existing North Carolina law, that class of nieces, it closes 10 lunar months after he dies. We know who the heirs are. The state administration goes on, it closes in due course. But what about if a niece is born 20 years later? Because that's a possibility. The uncle's sister could have children 20 years later. That is not that unusual of a situation. Under the appellant's position, that new niece, she has a right to inherit simply because she can show medical evidence that she is related, that she has that biological connection. Their position guts the outer limitation that 29-9 has served for all of these years. And so then we have precisely the problem that I think is under, kind of underlying the court's question about closing the estate. If we add to this class of beneficiaries 20 years later, how does she get her share? Does she sue the other heirs? Does she sue the PR for distributing assets before the class of beneficiaries is determined? The concern with the appellant's position is that it creates the new class of heirs that is open indefinitely. And so that creates a host of issues under North Carolina law, including how do we ever close estates? And for that reason, it would be a substantial change in North Carolina law. And when we have this situation, that becomes a question for the legislature. Now, Other states have adopted, some other states have adopted a Uniform Parentage Act that accounts for many of these issues. North Carolina has not enacted that act or anything quite like it. And even under that Uniform Parentage Act, it establishes time parameters and outer limits of inheritance. Because we've got to have some kind of outer limit here. If we have a simply genetics-only regime, there are serious consequences to that, including when do we close the estate? Can we ever do that? And so, again, it's not that 29-9 is outdated necessarily. It's just a matter of determining whether now that we have IVF, if we need to broaden that window of opportunity for IVF kids to inherit, and if so, by how much? And respectfully, all of the legislation that will need to surround that determination is something that should be done through the legislature. Because it's not just, yes, Noah can inherit, because then what about the next Noah a decade from now?
Well, doesn't it, in this particular case, Daniel and his wife actually chose the embryo, right? I mean, like, they went through the entire process. They chose the embryo that was to be implanted, and Daniel, because of his heart condition, died before the implantation. But isn't there enough circumstances there that his intent would be that that child would inherit?
And I think, Your Honor, the point that you're making is kind of captured by the Uniform Parentage Act in the states that have it. Because under that statute, there's not only kind of time parameters, but there's also an element of intent. But in this particular case, if we were to just say, well, clearly there was an intent here for this child to become born, then the outer limitation in 29-9, it still doesn't work. We still have open classes of heirs, because when someone goes to do a title search, they're not going to look and see, well, we don't know if because of intent, there's going to be a child born 10 years from now.
And you keep talking about 29.9, and I know you wanted to use it with,
The court's clearly very familiar with it, so I don't need to pull it up unless you'd like.
but I was gonna just ask you to, if you wanted to look at it, would be happy to do it. I knew you had expressed some interest in doing that.
Well, I'll tell you what, Your Honor, I think the point I was also going to make that I thought kind of might be helpful to kind of walk through the interplay of the statutes here was this. It pertains to the Noah should inherit because he's out of wedlock argument. And what I would say there is this. We all agree here that the right of the afterborn child to inherit begins at the pretermitted heir statute, 33-5.5. And in that statute specifically contemplates, not specifically contemplates, it specifically provides that the provisions of 28A-22-2 apply, not only to after adopted children, but also children born out of wedlock. So if we start with a pretermitted heir statute that specifically requires application of 28A-22-22, even for children out of wedlock, and then we go to 28A-22, that statute's qualified by 29-9. So my point that I was going to show is there's no way around 29-9. Doesn't matter if Noah's a child out of wedlock or not. You end up in each case at 29-9, and that's because it makes sense to have an outer limit.
How do you respond to the arguments made by counsel on the other side regarding Lankford, where there was an equitable adoption? And so the parties died before the adoption could be completed. Under the statute, subsequent adoption of a child by a testator makes them, of course, able to share in the inheritance, and the adoption hadn't actually occurred at that point. And so the court in Lankford actually used the equitable adoption theory in order to say that this person can inherit. How would you then, under the circumstances of this particular case, how would you distinguish this case from Lankford?
Well, I would start, Your Honor, with the language that the North Carolina Supreme Court included in Lankford that led with this. The sole issue in the case is whether North Carolina recognizes the doctrine of equitable adoption. So out of the gate, we're in a different situation than an unborn infant. We don't know what the class of unborn infants is going to be, but let's take that one step further. The court in Lankford also talked about a difference between a statutory requirement, a technical violation, and a substantive issue. And our case does not just involve a failure to comply with kind of statutory steps. It involves the failure to create the parent-child relationship And the court in Langford specifically said that equitable adoption is not intended to replace statutory requirements or to create the parent-child relationship. It simply recognizes that the foster child's right to inherit from the person or persons who contracted to adopt the child and who honored that contract in all respects, except through formal statutory procedures. So there was a contract. There wasn't the uncertainty that we have in this case here. Because while it is a certainty that Noah is here, there is immense uncertainty whether there will be another Noah next year, next decade, or something.
But doesn't that bring us then right back to Byerly and the rebuttable presumption?
And I believe the rebuttable presumption in Byerly is not a presumption of parentage, but a presumption of in utero. And here there is no contention that this child was not
But
in
it
utero.
doesn't say about in utero. I've read you the language twice, and it doesn't say anything about presumption that's in utero. It says presumption of whether, and the issue is whether they're the father. That's what Byerly said the issue was.
And Byerly also refers to the presumption of the in vitro se mare, presumption of being in the womb, which is different, in vitro se mare. So when I'm saying the presumption of in vitro, I should also be saying the presumption of whether the child was in the womb. But even if the court does not agree that Byerly stands for the presumption that the child was in the womb, this comes back to the fact that we didn't have IVF back then. The court was not distinguishing between in the womb and in the lab at that point in time. And so when the legislature overhauled the statute years ago and left 29-9 intact with its 10 lunar month restriction, it acknowledges that we have an outer limit. And for all of the policy reasons and concerns with the state administration, title issues, how do you distribute wrongful death proceeds, we contend to Your Honor that Byerly does not require a different outcome here.
And remind me again, how many days after the death of Daniel, this child was born? 300 and how many?
Yes, so 10 lunar months is 280 days, and this afterborn infant was born at 310 days. So we're 30 days after the 10 lunar month cutoff.
And 10 lunar months was set really to be 280 days, but it's actually 295, isn't it?
Your Honor may be correct about that. Thank you. Your Honors, the final point that I'll make today, subject to additional questions from the court, is this. And I heard the court mention this earlier, that the decedent could have accounted for the possibility of future children when he did his estate plan to begin with. He also could have updated his estate plan when he and his wife began the IVF process, but neither of those things happened. Now, we do in North Carolina have a statute to modify trusts, and this plaintiff has also asserted a claim to modify the trust for circumstances unanticipated by the settlor. That cause of action is still pending before the trial court. But what the appellant is asking the court to do here today is to create new law by changing 29-9 from being an outer limit and a true cutoff to a sheer genetic test by virtue of making it rebuttable by medical evidence. And so, Your Honor, again, we're here on the first cause of action today, and the court is asked to apply the law as written under 29-9 and to affirm the trial court's order. I'm happy to answer any further questions and appreciate the court's time today.
Thank you.
I'll keep my rebuttal brief, Your Honor, and I'd like to start with that last question that I think Ms. Kirk just answered that was originally posed by Judge Wood. Your Honor had asked counsel for Hasna and Noah whether Daniel's intent could have been better ascertained if he had updated his estate planning, and I 100% agree. It might be that we wouldn't be here today. But that afterborn child statute was adopted expressly to address this situation where somebody has done estate planning at an earlier time and for whatever reason has not accounted for the fact that other children, other heirs might come later. And, this a sad fact in this case is, if you look at the timing that's addressed in the complaint, this was a timing leading into COVID. And COVID, unfortunately, is something that interfered not just with medical care, as it did in this case, but also estate planning. So I think had things unfolded differently, had COVID not happened, would Daniel and Hasna have proceeded together in doing this IVF while he was alive, and would he have updated his estate planning? We'll never know that because he didn't get a chance to. And that is what brings us before this court on that afterborn child statute. Counsel for Ms. Clark has argued that 29.9 is a bright line rule, a flat cutoff, a strict time period. And I think as the Byerly Court made clear, it's not, it's a factual question. I think the issue specifically before this court is what is that factual question? And as Your Honor, Judge Arrowood has noted, the end of that opinion makes it clear the court's intent at that time, at any rate, was a question of paternity. So lastly, that brings me to the arguments made by Ms. Clark about, again, this Pandora's box, this parade of terribles about like what happens with an egg implanted 20 or 30 years from now. And I'll just submit to the court again, that's not the case before this court. The court doesn't have to reach that question. In fact, I'll draw the court's attention to the opinion in Woodward of the Massachusetts court who addressed this issue of an egg implanted after death. And there, the arguments were raised about, well, you know, what happens if this egg is implanted much later and how, you know, could that affect things? And the court simply found because the resolution of time constraints question was not required here, it must await the appropriate case should one arise. I think this court could take that same approach and deal with the question of time constraints at a different time because it's clear this is a very timely issue raised in the administration of the estate and brought before this court.
We could also take the position that the trial judge should not have dismissed it at this procedure and have all of this material decided at once, could we not?
Yeah, absolutely, Your Honor. As I said at the outset of my argument, I think there's two ways the court could find in favor of the appellant. One would be to address on the merits that the in-the-womb requirement does not apply and resolve that question as a matter of law, and the other to reverse and allow the trial court to proceed to develop a full factual record.
Would you address, you've got a couple minutes left, I believe, the argument that this is outside our purview and should be totally in the legislature's purview?
You know, I think this was addressed also by the court faced with the same situation, either in Kalachi or Woodward or maybe both. The legislature acts and it sets out a statute, and it's not an unusual situation for the courts to have to interpret those statutes. And again, the failure of the legislature when it updated the statutes in 2012 to make some affirmative rule at that point, I think cuts in favor of saying the legislature didn't intend to create a bright line cutoff, mandatory period at no uncertain circumstances. The child must be in the womb at the time of death. It could have said that in the statute, and it didn't. So I think the court is left with interpreting the statute as it is to address the claim of a very live child that is before the court. If that answers your question.
Thank you.
Thank you very much, Your Honor.
Thank you for great arguments. You've represented your clients very well. Case for hearing is IRA Club FBO versus Danzy. We will hear from the appellant.
May it please the court, good afternoon. My name is Scott Flowers. I represent the plaintiff appellant in this matter, IRA FBO Club Melissa Dahl. And I would like at the outset to reserve 5 minutes for rebuttal pursuant to the scheduling order entered by the court in this matter. Your Honors, I'm also.
And as I think we pointed out to you in the order, and I will point out to you in this case as well. There's not a time clock up here. You had a very complicated situation of how you were going to do this, which is fine. You need to keep your own time on that. I'll keep the overall time so that neither of you get more than 30 minutes, but how you're dividing it up is sort of up to you.
I appreciate that. And luckily I have a great timekeeper here to help me, so I'll try to mind that. Your Honors, I am prepared to argue our motion for relief from judgment if that will be permitted today.
Well, if we can start with that, why does that not simply raise factual questions that a trial court is better suited to? Wouldn't remand on that issue to the trial court to make a determination on those factual issues that were raised by the Rule 60B motion probably be the more appropriate approach there?
Sure. And Judge Hampson, we wouldn't object to that. We had to file that motion in this court because this court has jurisdiction, but I think it would be in this court's purview to remand the action for that purpose.
And we do that on a fairly regular basis if the parties ask us to.
Yes, Your Honor, and I believe that was, if it wasn't specifically part of our relief, it was certainly within the purview of what our expectation of the court's reaction might be. And so if that's your plan, I'll skip that. Otherwise, I'm prepared to argue the motion.
You can use your time however, you might have gotten some sense of what we might be thinking about doing there though, however. So you can use your time however you would like to.
Thank you. Well, I'll start with the facts because in this case, the facts are important and there are quite a few of them. So I'll do my best to get through the most important ones as quickly as possible. And Your Honor, as you've seen from the briefs, there are a lot of issues in this case from both sides, including the motion. But the facts and the timeline here are really important, not the least of which because this court has held that these types of cases are fact-specific. And so let me just start with a brief recitation of the important facts and dates. In February 2016, plaintiff and defendant entered into a lease agreement for the property that's the subject of this case, 2014 Quinton Street, Charlotte, North Carolina. February 2018, the parties entered into a new lease agreement. That lease agreement is in the record, I think at page 10. Things went fine until October of 2022 when the defendant issued a check for $59 that was insufficient funds, and the check bounced. As a result, at the end of October, the defendant had a debt on their account of $59 plus a $25 NSF fee plus a $15 late fee. So at the start of November 2022, the defendant had a deficit of $99. The defendant paid her rent in November of 2022, but did not pay the $99 deficit, which made her continue to be late, which added another late fee. So at the start of December, the defendant was in a deficit of $113. Again, in January, the same thing happened and a greater deficit created. Also in November of 2022, the landlord issued a lease renewal notice to the plaintiff. The lease renewal notice stated that you have two options, because at that time the defendant was a month-to-month tenant. The lease renewal notice stated that you could remain a month-to-month tenant and pay rent of $1,099, or you could sign a one-year lease and get a better rent of $999.
Was that lease ever tendered?
It's a lease renewal notice. There was never a lease signed after that date, Your Honor.
Are you contending there had to be for it to be $999?
Well, that's what the notice specified. The defendant.
Did your client tender that lease?
It was not a lease signed.
That was not my question. My question was, did they tender that lease and it wasn't signed?
Lease document tendered or delivered, if that's the question.
That was my question.
Yes, Your Honor. But the lease renewal notice informed the defendant that they had the obligation to contact the plaintiff and advise the plaintiff of their decision. And if the defendant failed to do so, then it would automatically be $1,099. So the onus was on the defendant to sign a lease and take advantage of the lower rate, which the defendant did not do. So in January of 2023, there was no signed one-year lease. Therefore, the lease payment was $1,099. The defendant only paid $99, which increased the amount that they were behind, which resulted in another late fee. In February, no rent was paid. A notice was sent out, a 10-day notice to pay or quit. The defendant did not pay. In March, the defendant did not pay rent. Another notice was sent out by the landlord to pay or quit. The defendant did not pay. Therefore, on March 27th, the landlord filed a complaint for summary ejectment. Now, this is important, Your Honor. The amounts sought in each of the pre-suit notices and in the complaint were the correct contractually owed amounts. The trial court delivered a judgment with something like 100 findings of fact. But I'm sure you probably recognized in reading that most of those items that are labeled findings of fact are actually conclusions of law. For example, the trial court, as a finding of fact, in one instance said that $49.95 as a late fee was unlawful. Well, that's a conclusion of law. It applies facts to law, and you review that de novo. Well, in fact, $49.95 as a late fee was not a violation of the law because the statute allows a 5% late fee, and $49.95 is 5% of $999. So if you go through the ledger.
So it's
Yes,
a percentage of $999.
correct.
And did your client accept some $999 payments?
In December of 2022, yes, Your Honor.
And was that what was owed that month? When did the new lease, or when did the new term start?
Again, it's a month-to-month lease, and the $1,099 was only charged in the month of January 2023.
And when did the lease expire? When do you contend the lease expired?
Well, as a month-to-month lease, it expires each month. It renews each month. There was no lease term beyond a 1-month lease term.
When did the initial lease expire?
Here from February 2018, so in February 2019, at which time the defendant went to a month-to-month tenancy. So, Your Honor, at the time that the complaint was filed, the amount set forth in the complaint was the amount owed. In fact, it was less than the amount owed because the plaintiff did not include the late fees in the amount sought in the complaint. Your Honor, so there was no,
With the finding of fact by the trial court, finding 19, landlord agreed the tenant's monthly rent would increase to $999 beginning December 1, 2022.
Your Honor, let's say that you find that there's competent evidence to support that finding of fact. Then the proper outcome would have been to adjust the amount owed in the judgment portion. Same thing that happens in breach of contract cases every day. This is a breach of contract case. The plaintiff sets forth the amount that they believe they're entitled to. The defendant raises their defenses. The trial court decides what's the proper amount owed under the contract. That is not an unfair and deceptive trade practice. That is what happens in courtrooms across the state every single day. It doesn't become an unfair and deceptive trade practice unless it's considered to be an unfair act, which is against public policy, immoral, or unscrupulous, according to this court, and there's proximate cause, damages, according to this court, which requires that the tenant actually pay the improper fee, which did not happen in this case.
But if we're moving to the unfair and deceptive trade
Sure.
practices and the damage award, the damage award was premised more on the window locks and the 15% reduction in fair market value attributed by the trial court to this. And that's how that damage award was calculated. It wasn't necessarily calculated on the late fees and the, wrongfully charged rent in that sense.
There were-
Isn't that right?
That's correct. There were
But there was,
two,
I mean, there was a debt collection violation act.
that's right,
9 violations, and that's the 4,500.
correct.
The damages specifically related to the, which were trebled as far as unfair and deceptive related.
Correct.
That came from the reduction in the fair market value of the rent based on.
Yes, Your Honor, but under Omnipopper, this case, and I hope I'm saying that correctly, I keep wanting to say Oppenheimer. Under Omnipopper, this court held that to establish Article 2, Chapter 75 damages, which are the fines, and I will address the habitability issue separately, because the judgments addressed them separately. But in order to have the Article 2, $500 per occurrence fine, you still have to have an unfair act and proximately cause damage, which requires payment of those fines. And that's what importantly distinguishes everyday litigation from an unfair debt collection practices act. It cannot be the case, Your Honor, that a landlord who mistakenly gets their math wrong in a complaint or a notice automatically equals an unfair and deceptive trade practice. That's not the law of this state. Our courts have consistently held that an Article 2, Chapter 75 violation, which is the statutory fine, requires the same elements as an Article 1 unfair and deceptive trade practice violation, which is an unfair, which equals against public policy, immoral, or unscrupulous act, not just a simple accounting error, plus proximate cause, which under Omnipopper requires actual payment. So that's important. That's what distinguishes just your regular litigation from rising to the level of a debt collection practices act. But importantly, I'm
Didn't
sorry.
the trial court find some aggravating factors here in that the late fees were continued to be charged even during the lower pendency of this action for the magistrate, while the lessee was paying the rent bond into the clerk of court? Isn't that part of sort of the aggravating factors that the trial court's looking to here to justify the
First of all, the trial court didn't style the judgment in that fashion. Secondly, under Chapter 75-54, it must be a false claim. Each of the late fees asserted were contractually due. Let me just explain with regard to the bond. First of all, the trial court did not include violation fines for late fees after April of 2023. So the May, June, and July late fees were not part of the trial court's decision and are really not before this court. The trial court specifically stated that there were 9 violations, the 2 pre-suit notices, the complaint, the 3 $15 late fees that occurred pre-suit, and 3 $49.95 late fees that occurred around the time suit was filed. But even if the late fees, and all of those were contractually owed and consistent with the statute, despite defense's brief that $49.95 is in excess of the statute, the math just says it's 5%. So, I mean, that's a fact. But Your Honor, I'm sorry. With regard to the bond issue, if I may address Judge Hampson's question, the bond statute, which I believe is 42-34, says that to stay execution, you must pay the rent that's contractually due. After the late fee is assessed, in other words, on the 6th day of the month, the late fee is contractually due and becomes part of the rent. Everything that's due is contractually due, whether you call it rent, a late fee, or whatever. It all arises from a contract, and that's what the statute says. The defense argues that the bond says that there's 5 business days to pay the late fee. That's not true. Look at the language of the bond. The language of the bond says it automatically dissolves if it's not paid by the 5th business day. It doesn't say anything about a contractually due late fee. The case cited by the defense in their brief for the proposition that you couldn't add, that a landlord couldn't add the contractual late fee once a bond is placed, doesn't apply here. And here's why. Because in that case, the tenant actually paid the rent into the clerk on time prior to the 5th day of the month. The landlord complained about the clerk taking time to get it to the landlord. So when the tenant made the payment into the clerk, the late payment was not, quote, contractually due under 42-34. In this case, on each occasion, the tenant paid the clerk after the 6th of the month, and therefore, the late payment was contractually due. The earliest that the defendant ever paid the bond was the 8th of the month. So even those $49.95 charges were contractually due. But by the way, Your Honor, even if they
Remedy,
weren't,
though, to seek dissolution of the bond and dismissal and for possession?
they could have, they did not. Is that your question?
I'm asking, wouldn't that be your client's remedy, is to move for dissolution of the bond and for dismissal of the appeal to the trial court?
That would be a remedy. But that doesn't mean they're not entitled to what's contractually owed under the lease when you get to trial. And by the way, the subsequent bond payments were not included in the complaint. That happened after the complaint was filed. But again, it wasn't part of the 9 items listed by the trial court. And even if they were wrong in assessing late fees to the account, again, that's not an unfair and deceptive trade practice. That's not against public policy of the state. That's not immoral or unscrupulous. And there was no proximate harm because it wasn't actually paid. I'd like to address the habitability issue.
I've
Yes,
got a procedural question here.
yes, Your Honor.
This was started as a summary ejectment,
Correct,
and then there was an appeal,
correct.
and then there were a series of counterclaims brought.
That's right.
I know in magistrate's court, you're not required to file a reply to counterclaims. 7A 220 talks about that once there's an appeal that you can bring counterclaims and all of that, and that it's to be governed under Rule 1A1 et sec of the statute,
Correct.
which is the rules of civil procedure.
Correct.
I don't see a reply anywhere to the counterclaims filed in district court.
There was not one, Your Honor. There was not a reply. And as you said, there was no requirement for a reply.
Well, there's no requirement for a reply in magistrate's court,
Right.
but what about the requirements of 7A 220?
Your Honor, the defendant didn't file, I'm sorry, the plaintiff didn't file a reply to the counterclaim in this case, but the defendant didn't seek to default the plaintiff, so really that's,
But doesn't Rule 8 say that if you don't file a reply and you're required to, that the facts are deemed admitted?
if an entry of default is entered, which it was not. But let's look at the facts of that counterclaim. Where are the facts? The facts are the amounts charged by the landlord. Well, we don't dispute those facts, Your Honor. We don't dispute that the landlord charged $49.95 late fee. We don't dispute that the landlord charged $999 in December. We don't dispute that the landlord charged $1,099 in January. Those are the facts that are pled. The statements that the $49.95 late fee was impermissible under law is not a fact. It's a conclusion of law. So we don't dispute the facts. There are very scant facts. But, Your Honor, that goes to the issue of the warranty of habitability because, as you know, what was not in that counterclaim was a claim for the breach of the warranty of habitability. There was no notice prior to trial that the defendant intended to bring such a claim. It was not pled, as is required by Rule 8. There was no pretrial disclosure. If you read the transcript, Your Honor, there was questioning about the financial charges, which were part of the pleadings, and then immediately defense counsel started asking about these windows with no notice whatsoever. And keep in mind, Your Honor, this is a trial that was over WebEx. So you've already got communication issues going on. But immediately, there's a transition into asking questions about an entirely new and different claim. Now, Your Honor, we're not talking about whether an expert can offer opinions in excess of their original opinions. We're not talking about whether a plaintiff can offer additional damages in excess of damages previously disclosed. Those are the types of things that were going on in the cases cited by the defense. Importantly, we're talking about a completely new and different claim that has nothing to do with the claim brought in the pleading. Your Honor, the defense states in their brief that plaintiff is trying to avoid a trial on the merits on this issue by raising the fact that it wasn't part of the pleadings and saying that that's a technical type of argument. But Your Honor, it's not a technical argument. It is the most important thing. Notice and an opportunity to be heard is what all the rules are about. Every rule that deals with jurisdiction, service, all of that is about notice.
Well, aren't there really two questions here? First question is, was this evidence properly admitted for any purpose? And two, was this claim properly done? And those are two separate questions. And I would ask you to address, why isn't the lack of locks and the evidence therefore properly admitted to determine where they have denied the amount of the money owed under the lease?
Your Honor, it goes to an affirmative defense and a counterclaim of abatement and breach of warranty of habitability, both of which are required to be pled by Rule 8. We know what the purpose of the evidence was. Defense counsel argued it when plaintiff's counsel filed a motion. Defense counsel said, well, if they owe us money for the breach of warranty of habitability, that defeats the summary ejectment claim. That was the purpose. There's no secret about it, but it wasn't part of the pleadings. It is a completely new and different claim. It is ambush litigation in the worst sort of way, Your Honor. There was no opportunity to defend that claim. There was no witness there who could speak to that. There were no documents there. The testimony of the defendant was that in 2016, she had told the landlord of these broken locks. 2016. So this is a 7-year-old item that supposedly was communicated to the landlord. There was no opportunity to defend. And under Rule 15G, there can be no implied agreement to try the issue unless there is no objection and there is no prejudice. There was a timely objection. And by the way, you know, one of the things they argue is that the objection wasn't timely. Well, how fast do you have to be? I mean, I'm a trial court lawyer. We look to you for guidance. I have to be respectful to the trial court and to opposing counsel. Am I supposed to jump up and start screaming? I mean, what's the requirement here? Plaintiff's counsel immediately objected before the line of questioning was completed, before the exhibits were admitted. The cases that are cited by the defendant on this issue don't apply here. For example, one of the cases involved a situation where there was a letter tendered as an exhibit. The letter was admitted without objection. The party offering the letter did all their questions. The other party did all their cross-examination. There was no objection. The next day, the opposing party came in and objected to the letter being posted to the jury, and the court said that's too late. The North Carolina State Bar case, the court found that the evidence offered during the hearing was not substantially different from the allegations in the complaint. So another case that they recently offered was the case where the sheriff read a 2-page witness statement, and at the end of the witness statement, the defense counsel objected on the grounds of hearsay. And the court said it wasn't prejudiced because the same evidence was already in the record. None of this goes to a new and completely different claim. There was an objection. There was no implied consent. There was certainly prejudice. The trial court, as you pointed out, Judge Hampson, based almost the entirety of their damages upon this counterclaim that was never pled. So there was clear prejudice, Your Honor.
Did you request a continuance?
No, Your Honor, and Rule 15 doesn't require it. Rule 15 says that the trial court may grant a continuance. There's no onus on a litigant to request a continuance. The only obligation that this court has found is that there be a timely objection made. There's no obligation to request a continuance. And by the way, if you look at the transcript, there was no opportunity to request a continuance. The trial judge immediately overruled the objection and moved on. The trial judge didn't allow for further argument. And again, what is a practitioner in the trial court supposed to do? You lodge your objection. And by the way, plaintiff's counsel didn't lodge a general objection. Plaintiff's counsel specifically objected that the line of questioning was outside the scope of the pleadings. So the objection was made, and it was made timely during the course of the examination prior to the photographic exhibits being offered. The objection was preserved. And please look at the overall circumstances of the case.
Going back
Yes,
to
Your Honor.
Going back to Judge Arrowood's question, though, why would this evidence not be generally admissible on the broader question in the summary ejectment context of whether there was, in fact, rent owed?
Because Rule 8 requires you to plead this type of defense affirmatively. And the only counterclaim, if you read the counterclaims, the only counterclaims alleged were all financial counterclaims. They challenged very specific charges to the account. They laid out the charges. There was no catch-all. There was no catch-all counterclaim. There was no catch-all affirmative defense. It was very specific. These charges were wrong. These charges create an Article 2 violation. These charges create an Article 1 violation. They're not, there's no warranty of habitability at issue whatsoever. It wasn't raised in any way. It's a completely new and different claim. There was no proper purpose. And by the way, the trial court didn't find there was another proper purpose, and defense didn't argue in their brief there was another proper purpose. Defense didn't argue at trial there was another proper purpose. That argument is not before this court. It hasn't been preserved or made by them in any fashion. I see my time has expired, and be glad to answer any further questions before I have a seat. Thank you, Your Honors.
Thank you, Your Honor. May it please the court. I'm Ethan White from Robinson Bradshaw. And I, along with my co-counsel, Tommy Holderness from Legal Aid of North Carolina, represent the defendant appellee / cross-appellant in this matter today, Ms. Mona Lisa Danzy. And I'll note for the court that Ms. Danzy is here with us in the courtroom. At this time, I'd like to reserve 3 minutes of my time for rebuttal on issues solely related to Ms. Danzy's cross-appeal, knowing full well that it is on us to keep track of how we are splitting this up, Your Honor. Ms. Danzy asks today that this court affirm the trial court's order below in its entirety, except for the single issue of the trial court's calculation of damages on Ms. Danzy's unfair or deceptive trade practices counterclaim, which is the subject of her cross-appeal. Now, in keeping with the agreed-upon format for the arguments today, I will proceed through the issues in the following order and, where appropriate, address matters that concern both appeals. First, I'll touch briefly on the Rule 60B motion that my colleague across the aisle mentioned, because it sounds like Your Honors may have some questions there. Second, I will address Ms. Danzy's counterclaim for unfair and deceptive trade practices, because again, that is the counterclaim where her cross-appeal deals with two discrete issues of how the trial court below calculated damages on that counterclaim. I will address both IRA's appeal and the cross-appeal there. I'll then continue on to the trial court's ruling on Ms. Danzy's counterclaim for unlawful debt collection practices, and finally conclude by talking about the trial court's denial of IRA's claim for summary ejectment.
Well, with respect to the Rule 60, you can talk about it if you'd like, but why isn't this is totally appropriate to send back to the trial court?
Well, yes, Your Honor. So, and I don't want to spend too much time on this, but to answer your question fully, it's for the reasons that we set out in our responsive briefing. So there are really 4 reasons. One is that any Rule 60B motion needs to be made within an appropriate amount of time. And here, what IRA has done is submitted a Rule 60B motion with new affidavits attempting to contradict or controvert the testimony at trial a year after trial, and 9 months, I believe, after the trial court's final judgment here. It has given no explanation, nor can it give one, for why it waited that long to do this. And this all sort of blends into the other issues here. So that's the first. The second is that it is argued under Rule 60B2, the new evidence grounds for relief from judgment, that relief is appropriate here. But for Rule 60B2 to apply, the new evidence that is brought to light has to both be evidence that existed at the time of trial and be evidence that could not have been gathered and put before the trial court in time for Rule 59B motion for a new trial. And here,
Or better able to make for us to send it back in the trial court to make a ruling on that rather than us?
well, Your Honor, the trial court could rule on that, and we're not contesting that, and if the court wants to do that, it certainly can. However, our position is that it's not necessary to take that additional step. IRA has made the motion before this court, it is before this panel, and it is not appropriate and it's not supported. So rather than take it back to the trial court, it would be appropriate for this panel to just deny the motion. And as I was saying, it's because there's no explanation for why this motion is now brought a year after trial, 9 months after the final judgment. It is not new evidence under Rule 60B because one, it's sort of the evidence put before the court falls into two buckets in the two affidavits. And the first is evidence of that attempts to contradict Ms. Dancy's testimony below as to facts that existed at the time of trial, whether or not the windows, there was a complaint made about the window locks.
Well, speaking of that,
Yes.
so it looks as though the court made a lot of its findings about unfair and deceptive trade practices on the claim of uninhabitability. And it doesn't escape my attention that is not pled anywhere in this counterclaim. So, I mean, it did not put the plaintiff on notice, which is, North Carolina is a notice pleading state, that was even going to be argued at trial. So how were they able to prepare and to present evidence at trial if they didn't know it was going to be argued at trial?
Certainly, Your Honor. So to directly answer that question, this is going to sort of blend some points that I plan to address in several topics today. But IRA did not argue below, and this touches upon our Rule 15B argument, but IRA was required to and did not argue prejudice by this evidence below.
So they objected, didn't they? And said it's not pled. I mean, what else are they supposed to do?
Well, Your Honor, this court has actually answered that question in the Smith v. Buckram decision, which is, we say, controlling here, because in that case, what occurred was there was a plaintiff who had a claim and at trial introduced evidence of permanent disability, which was not a part of the basis of any of her claims in the complaint, and did not formally move to amend the pleadings to conform to the evidence. And the defendant on appeal objected and argued that was, well, they objected below and on appeal argued that evidence was not properly before the trial court. And what this court said was, no, it was. And the reason for that was because although the defendant below had objected, they did not show any prejudice from the evidence as Rule 15B requires them to do in order to prevent an amendment from to conform the pleadings to the evidence from happening. And they also did not move for a continuance as Rule 15B permits. So with those two things together, this court concluded that the evidence was properly before the trial court. So that goes to Your Honor's question of did they show prejudice or argue prejudice? Our position is no, because as Smith showed, there's a difference between objecting and actually showing prejudice. And in Smith, there was no showing of prejudice, and here there was no showing of prejudice. And I think, because like I said, this will sort of cover some of the topics, several of the topics that we'll be addressing, I think it's important to sort of take a step back and realize sort of a couple of sort of more fundamental things. One is that in a case like this, in the district court where there's no discovery below, it is not uncommon for evidence to come in trial that provides a new and separate basis for an award on an already pled counterclaim. And it is also not unusual for evidence to come in at trial that is outside the scope of the pleadings. And in fact, the law addresses that because we have Rule 15B to address, to deal with situations like that.
Is there a difference in this evidence kind of coming in defensively, right? To show sort of a set off or abatement against rent, or that, in fact, perhaps rent was not owed for certain months during the time of the alleged defect, versus it being used offensively to support a damages claim again, and in turn support an unpled theory of unfair and deceptive trade practices.
Your Honor, we are not aware of any controlling authority that says that once the evidence comes in, it comes in for some specific purpose, but not another, particularly here where there is no sort of, recognizing it was a bench trial, it's not a jury trial, but there was no sort of limiting instruction or any request from IRA that the evidence should come in for one particular issue and be applied in one particular way, but not another. There was an objection made that it was outside the scope of the pleadings. That objection was overruled. And so our
Mr. Holden has, I believe, argued that the claim for rent owed can be defeated by the violation of the warranty of habitability and no rent was owed. That was his argument when the trial court overruled the case. I guess my concern may be, how do you get from, not whether it was improperly admitted, but how do you get from there to a large judgment for unfair and deceptive trade practice from this evidence, when that, I don't see that being pled anywhere in your counterclaims?
Your Honor is correct that it was not pled in the counterclaims, but as I said, it is our position that there was no limiting instruction asked for. There was nothing like that. Once the evidence was before the trial court, it was properly before the trial court and in the record, and the trial court was able to.
Well, the trial court handles all kinds of different cases on a regular basis. For example, when I was a district court judge, I heard cases in juvenile court where there was evidence for adjudication, disposition, all jumbled up together. And this court has consistently held that it's up to the trial court to determine what evidence is appropriate in which kind of disposition, whether for adjudication or disposition, and that is within the purview of the trial court. But it recognizes that the trial court has a duty to determine if it's for defensive or offensive purposes, doesn't it?
Your Honor, I'm not as familiar with you are obviously about that situation, but I would agree with Your Honor that it is up to the trial court here, subject to this court's review, but on a discretionary basis, how it uses the evidence before it. Here we believe that it's appropriate for it to have ruled for Ms. Dancy on the unfair and deceptive trade practices claim on this basis. But I want to get back to this point about sort of the unfairness, the due process argument that has been raised several times through briefing and here at trial today. And that's because, as I was saying, it is not unusual for evidence to come in like this at trial. And so the law provides both Rule 15b, but also options for a party to deal with that evidence. And here, both before, during, and after the trial and after the judgment, IRA had options for how to deal with this evidence, and it, perhaps for strategic reasons, did not exercise any of those options. Now, before trial, it is confirmed twice in the trial court transcript below, both on pages 6 and 45. Trial court judge confirmed with IRA's counsel that everybody here had received the proposed exhibits for trial beforehand, and those exhibits included 2 pictures of the windows that did not lock here, which were admitted as exhibits at trial. So IRA received those exhibits beforehand. There was nothing in the counterclaims or answer about these windows. So IRA was then put on notice that there was something with the windows that was going to potentially come in.
When was IRA put on notice that they could be facing a claim for damages, which would then be potentially trebled based solely on the defective window locks and not late fees and unfairly charged rent and that sort of thing?
Well, I think, Your Honor, that would have been, or the first time that was concretely in the case was at the final judgment, when the court took that evidence in at trial and in its discretion elected to use that evidence not only for the defensive aspect here, but also for the award of the unfair and deceptive trade
Well,
practices claim.
and my question is not whether it was properly admitted, but my question is, how do you get, does the trial court then, when could they have made the motion to, I know, and I understand your argument, well, they didn't do what they needed to do to preserve it, but it seems that, as I think you just said, that the trial court, the first time the trial court used it in unfair and deceptive was in the judgment itself. So how have they had notice of that is my question to you.
Well, Your Honor, at the very least then, that moment is when they had notice of that. And as I touched upon already, the law also gives you a tool in your toolbox to use in that situation, and that is the motion for a new trial under Rule 59B. And as we've talked about in our briefing, the evidence that they have tried to submit now is either sort of the second bucket is evidence that is about facts that are in existence a year after trial. So that's not properly before the court on a Rule 60B motion at all, or evidence that they are attempting to introduce of the facts as they see them at the time of trial.
I have a question about the windows, since we're on the windows at this point, and
Certainly.
your statement that they were shown pictures of broken windows prior to trial.
Yes, Your Honor.
Your client started this in 2016, is that right?
That's correct, Your Honor.
And then there was a subsequent lease that was signed in 2018.
I believe it was a summary of lease terms, but I believe both of the sides have agreed that that is sort of a controlling set of terms here at this point.
And in the summary of lease, or the lease summary in paragraph 8, there's a sentence that says tenant will be responsible for the following: repair or replacement of broken or missing windows, doors, screens, or glass. And then when you go to number 11, it says tenant hereby agrees to notify landlord in writing of any necessary repairs. So how would the landlord then be on notice that there's some problem with the the broken windows, and there's this defensive inhabitability when there's a lease that says that the tenant's responsible for the repairs?
Well, so I would make 2 points in response to sort of address both of the points that Your Honor has made there. The first is that although the lease says that the obligation is on the tenant for the windows and doors, et cetera, that would be overridden here by Charlotte's Housing Code, which says it's the landlord's responsibility to ensure that an imminently dangerous condition does not exist on the premises.
Did your client notify the landlord in writing that there needed to be repairs?
Yes, Your Honor. The uncontroverted evidence in trial from Ms. Dancy's testimony was that she notified IRA here through its management company, both orally and in writing after she moved in. And that despite that,
16.
in 2016, yes, Your Honor. At the beginning, she notified them in writing. They told her to write the complaint down on a piece of paper. She brought it into them. But
Paid rent for 7 years
that's correct, Your Honor.
without telling them again that there was an issue?
Well, Your Honor, I think her testimony on that point was that she had made the complaint. Nothing was ever done about it. And I think her words were she didn't want to be a bother, but that should not excuse IRA from violating Charlotte's Housing Code and from allowing an imminently dangerous situation to exist on the premises. All the while, it is still collecting rent that Charlotte's Housing Code says it is barred from collecting, and in fact makes it a misdemeanor to collect. So
That's a breach of contract, and that occurred back in 2016 when she notified them in writing that there was this problem or whatever, and she didn't notify them again. Isn't there some sort of limitation on this thing? She kept paying rent and never notified them again for the next 7 years until she gets the summary of judgment notice.
So, Your Honor, there are a couple of important points that I'd like to make in response to that. One is that the other side has characterized this as the unfair and deceptive trade practices counterclaim here as a breach of contract with, aggravating circumstances that they say is not present here. That is not the kind of unfair and deceptive trade practices claim that Ms. Dancy is bringing here and what the trial court awarded. What the trial court awarded Ms. Dancy was an unfair and deceptive trade practices claim based off of precedent from this court that says where you have defects in a home or code violations, you have the landlord on notice of that. The landlord still continues to collect rent, however, and does not fix those code violations, that in and of itself constitutes an unfair and deceptive trade practice. So
Aren't those in cases, though, where the tenant had continuously complained that there continued to be problems that were never fixed by the landlord?
Your Honor, it very well may be the case that in some of those cases, the tenant continued to complain, but I'm not aware of any legal authority that says that that is a requirement for the unfair and deceptive nature of what's going on to attach. It is the fact that there is a known code violation. It is not remedied. The rent continues to be collected. That is what this court in the past has found constitutes an unfair and deceptive trade practice here. But having sort of touched on the Rule 60B motion, I want to make sure that I turn to this issue of the window locks because a lot has been made of it in the briefing. So as it relates to IRA's appeal, the trial court's consideration of the window locks evidence was proper here, and it was so for 2 independent reasons. And the first is that IRA's objection to the evidence coming in from Ms. Dancy was too late. And when a party fails to timely object to an issue, on an issue, it waives the objection and it does not preserve the issue for appeal before this court. So indeed, this court need not consider the issue of whether the window locks evidence was properly before the trial court at all, because IRA's objection was untimely. And I'd like to particularly draw the court's attention here to the cases that we cited in our memorandum of additional authority, because my colleague across the aisle made the comment of, well, how quick does an objection have to be? Well, the case law tells us. And the first decision on that point is the State v. Reed decision from our state Supreme Court. And there it held that a defendant's objection at trial was untimely when a witness had already provided the objectionable testimony, the objectionable answer, and then just one additional question and answer had been asked and given. And our state Supreme Court held there that that was an untimely objection, even in the criminal defendant context, when the law is making every effort to try to make sure that the defendant receives a fair trial. This court's decision in State v. Hyder, which is the other decision we cited in our memorandum, is much the same. There, a court held that the objection to the reading of a witness's statement into the record after most, but not all, of the statement had been read into the record was also untimely. And so here, what these decisions, the result these decisions compel is that IRA's objection was also not timely. Ms. Dancy's counsel at trial asked a series of questions that showed two things clearly. One, that the evidence of the broken window locks was coming into the record, and two, evidence concerning IRA's notice, both oral and written, was also coming into the record. Now, these issues, as your honors have noted, was not in the pleadings, but Ms. Dancy testified as to all of the essential facts necessary for the trial court to make the award here, that the window locks did not work, that she had notified them, that they had never been fixed, and that she was paying rent. And it wasn't until after these essential facts came in, and Ms. Dancy's counsel below asked the additional question of, why exactly mechanically is the lock not working, that IRA's counsel objected. This situation is thus on all fours with the cases that I just mentioned, where indeed, if in State v. Reed, one question and answer session is too far, the objection here was 10 times too late. Ms. Dancy, I believe my colleague across the aisle attempted to distinguish one of these decisions because there were 2 pages of a statement put in here. Well, if you go to the trial court transcript, there are 2 pages of questions and answers asked before the objection is made. And I want to make a clear distinction here for the court. The issue of the untimely objection is separate from the Rule 15b analysis. This goes to the bedrock principle that if an objection is not made in time, it is waived and it is not preserved for this court.
Well, wouldn't the information been able to come in anyway, maybe as a defense? But we're talking about the fact that it wasn't pled as a counterclaim.
Yes, Your Honor. So that brings me actually to the next point, which is that even if the court considers the objection timely here and wants to look at what was in the pleadings versus what was not in the pleadings, here, Rule 15b answers that question for the court and says that the pleadings in this situation are amended to conform to the evidence.
But when exactly then was there ever, looking at it from a admissibility standpoint is maybe defensive to come in and defeat the claim for summary ejectment. That's one thing. Where did Ms. Danzy request an award of damages based on a counterclaim for the defective windows themselves? Like, where was where was the request for that to happen offensively?
So what I would say in response to your Honor's question was that request was not made in the trial transcript. And as Your Honor noted, the trial court here used its discretion to make that award based off the facts before it. But where that was made was in the trial court's judgment. And on this point, Rule 15b is clear that simply because evidence was outside the scope of the pleadings at the time of trial will not affect the result of the trial. And even where a formal motion is not made to conform the evidence to the pleadings, the state's appellate courts will presume it to have been made. So the situation that we get into is, no, this was not part of the counterclaims as pled in the answer and counterclaims pleading. But what happened here was that it came into trial.
Were there closing arguments in this case?
Yes, Your Honor, there were.
And Was it a part of the closing arguments in this case that that's another basis for unfair and deceptive?
Your Honor, I do believe that below Ms. Nancy's trial counsel both noted that because of the window locks evidence that she did not owe any rent and thus could not be evicted. But also, I believe he did make the comment in his closing argument, in fact, that they owed her money back. So on that basis, the trial court could have taken the evidence in the record that was properly before it and that argument together as a request for the result that occurred here. But we would say again that
Was it argued that it was another basis for an unfair and deceptive?
Your Honor, I don't believe that it was, if that particular basis, if it was put into that sort of bucket of the counterclaim pleadings, but it was certainly an argument that was made, and it does not have to be the best argument made. It does not have to specifically fit into that bucket. We would argue for the request to be in front of the court. And like I said previously, this is very much controlled by the Smith v. Buckram decision, in which evidence outside of the pleadings came in to support an additional basis, the permanent disability award at trial. And because the party there did not ask for a continuance and did not use the opportunity when it was objecting to show prejudice, this court concluded that that evidence outside the scope of the complaint in that case was properly before the trial court. And here it's
I
very...
guess what's troubling me is they didn't ask for a continuance, but when did they know they should have asked for a continuance? That's what's troubling me here. Not that it came in, but what happened afterwards.
So, Your Honor, what I would say to that is, well, what I said previously, there were several stages in this case in which IRA could address this issue. We've talked about before, the receiving the proposed exhibits. We've talked about at trial. But as you have said, when could they address this specifically? When it was concrete that it was in the judgment that this was a basis for the trial court's award. And what they could have done and should have done there was move for a new trial under Rule 59B. They should not have waited a year after trial and months after the judgment in the middle of briefing in this court to try to bring a Rule 60B motion that is not appropriate and not supported. But again, perhaps there were strategic reasons they elected not to make a Rule 59 motion, but this is now the record that we have. And so for all of those reasons, well, both the untimeliness of the objection and the failure to demonstrate prejudice as discussed in Smith v. Buckram, the issue of the window locks was properly before the trial court, and it could and did use that evidence as a basis for the rule, the unfair and deceptive trade practices counterclaim. I know my time is short. I want to just touch on one point quickly that my colleague across the aisle made on the unlawful debt collections practices counterclaim. Now, IRA has argued that because no monetary damages were paid out here, that these unlawful charges were not paid by Ms. Dancy, that she does not have a claim here. And that relies on a line of decisioning, a line of decisions that all go back to this court's decision in Reed v. Ayers in 2000. And as we've discussed in our briefing, what's important to note now is that Article 2 of Chapter 75 used to be written very differently. And since Reed v. Ayers, it has been amended to make clear that monetary damages, out-of-pocket damages, are not necessary for an unlawful debt collections counterclaim to be made. And the statute, as amended, makes that clear in several ways. First, the new language, it did not used to read this way, provides that any debt collector who fails to comply with the provisions of this article is liable to such persons, quote, in a private action. Now, the way the statute used to read just said in private actions, and then it gave some limitations on trebling and the maximum award of civil penalties. But the statute makes clear now that there is a private action for a violation of Article 2. And what Reed had done was, because there was not a separate cause of action, it had concluded that it was appropriate to think that the General Assembly had intended for these claims to piggyback off of the requirements of 75-1.1 claim and thus require approximate injury. But the amended language now makes clear that that is not necessary. And it also makes clear that the penalty that can be awarded, or the amount that can be awarded, is, quote, the sum of, quote, any actual damages, and two, quote, civil penalties. So the use of the sum and any there also makes clear that, as amended now, the General Assembly intends that your damages are going to be both any, if any, actual damages that you have, as well as the civil penalties where there's a minimum of 500 and a maximum of 4,000 per violation.
And you've got about a minute and a half left.
Thank you, Your Honor. I'll reserve the rest of my time for rebuttal.
Your Honors, I'd like to begin by addressing the final point made by opposing counsel with regard to Article 2, Chapter 75, and that the 2009 amendment changed the analysis. No court has held that, not federal, not state, other than bankruptcy court cited in defendant's brief who didn't even take up that issue. That bankruptcy court held that you couldn't treble civil penalties. No court has held that. Omnipauper, this court, just last year specifically in an Article 2, Chapter 75 case where the landlord was sued for charging the tenant 29 different times to use the landlord's well to obtain water and for putting in the complaint more than the landlord was contractually due, was sued under Article 2. Very similar facts. And the court held that in that case, under Article 2, Chapter 75, there must be an unfair act and there must be proximate cause, and proximate cause means payment of the unlawful fee. That's the law of this state. Further, just last week, Chief Judge Catherine Eagles, in a case in the Middle District of North Carolina that just hit Lexus this morning from what I could tell, and I'll give you the cite on that.
Probably best if you submit a memo of additional authority rather than cite cases that weren't.
Sure, I'll do that. I'll do that. But Judge Eagles held just last week that, and cited Omnipauper and said that's the law of the state of North Carolina. Article 2, Chapter 75 claim you must have prejudice. And Judge Eagles held that's the law of the Fourth Circuit.
Of course,
So
now, we're not bound by what Judge Eagles said.
you're not, but she's a lot smarter than me, Judge Arrowood. And,
You might be a lot smarter than me too, but that doesn't mean I'm bound by what she.
you're not. But she's saying that both this court and the Fourth Circuit are consistent in this analysis, and that's good enough for me. Moving on, Judge. The opposing counsel talked a lot about we should have made a Rule 59 motion. That doesn't excuse errors by the trial court, the lack of a Rule 59 motion. Secondly, Your Honor, the affidavit of Ms. Howard makes clear that within 7 days of the order being entered, she contacted defendant Ms. Danzy, requested access, and was denied access. Rule 59 requires the motion to be filed within 10 days. They weren't able to get access within the 10-day period. They weren't able to get the evidence needed within the 10-day period.
But the Rule 59, they're talking about the Rule 59 motion is about, in the Rule 59, not going to whether or not they got access and whether or not the locks were working, but whether or not it was proper for the court to rule on all of these things as an unfair and deceptive trade practice that wasn't included in the pleadings. Isn't that?
Well, Rule 59 is not designed to just get a do-over. That's not what the trial judge does under rule. You have to have a reason for it. And the reason in the Rule 60 motion was.
But your
evidence.
argument with the reason is that, well, you considered things that were not in the pleadings, or, and isn't that a Rule 59 motion? I just respectfully disagree with you that it's about the locks themselves.
Point well taken. I can only tell you that in this case, the basis of the Rule 60 motion was the newly discovered evidence, Your Honor. And in this case, plaintiffs sought relief from this court for the errors of the trial court, Your Honor. Your Honor, I'd like to talk about the cases cited by opposing counsel with regard to preserving the objection. And those three cases were State v. Reed, State v. Hyder, and Smith v. Buckram. First of all, which opposing counsel says Smith v. Buckram was the main case here. In that case, we're talking about a chiropractor was testifying, and for the first time, the chiropractor in a negligence case testified that the plaintiff had a permanent injury. So we weren't talking about a new and completely different claim. We're just talking about additional evidence of damages. And the defense counsel simply said this was the objection. Objection. That was it. There was no basis given. So the trial and the chiropractor had completed his line of questioning and moved on to another line of questioning. So the court said it was within the pleadings, we're just talking about damages. You didn't tell the trial court what the basis of your objection was, and you waited until they were off on a new line of questioning. That's not at all similar to this case. In State versus Reed, the trial court analyzed criminal procedure statute 15A-1446. That was the issue in that case. By the way, 1446 has 20 exceptions to it. 19 enumerated and then a substantial catch-all. It's a completely different situation. Doesn't apply here. But again, they were talking about expert testimony and the limits of expert testimony, not a new and completely different claim. Finally, State v. Hyder is the one we talked about where sheriff read a 2-page witness statement. The court said you weren't prejudiced by it because it was already in evidence. And by the way, again, all he did was objection, and it was a hearsay objection. None of those cases apply here, Your Honor.
I believe you
Yes,
are
sir.
at the end of your time.
Emma? Well, thank you all very much for your time.
I'll give you 30 seconds to sum up if you'd like.
Thank you, Your Honor. Your Honor, we ask that the lower court be reversed because the competent evidence shows that the plaintiff was entitled to summary ejectment, because there was no Article 2, Chapter 75 violation, because plaintiff was not given notice and due process with regard to the warranty of habitability issue. But even under those circumstances, there was no breach of the warranty of habitability, because this court has consistently held that that is a case-by-case factual analysis, which the trial court did not undertake in this matter. Thank you, Your Honors.
You have about a minute and a half.
Thank you, Your Honor. I would just like to note that my rebuttal is meant to be solely on issues related to Ms. Dancy's cross appeal. IRA has not made any argument in its briefing, however, in response to the points that we have argued on our cross appeal. One, that the trial court incorrectly did its math below and should have set the fair rental value here at $0 because of Charlotte's housing code in calculating damages. And two, even if the court disagrees with that, that under this court's binding case law, how you offset and treble actual damages, when you have both an offset and trebling that needs to occur, you're supposed to treble them first and then offset second. Here we've argued that the trial court did its math in the wrong order by taking the actual damages, subtracting the offset, and then trebling the reduced amount. IRA has not disputed either of those arguments in its briefing, and I've heard nothing from my friend today about that. So I would just say in conclusion that, again, Ms. Danzy's asking this court affirm the trial court's order below, except as to those two discrete issues about the calculation of damages on the unfair and deceptive trade practices claim. And with that, I'll yield the rest of my time. Thank you.
Thank you. Thank you, counsel, for excellent arguments.
Your Honors.
Extension of North Carolina.
That's what Judge Bledsoe, business court judges usually.
Yeah, thanks.